Everybody, attention please, just a courtesy reminder that silence your cell phones and electronic devices, where you won't be served this afternoon's oral arguments, and we will start momentarily. Thank you. That's why All persons having business before the Honorable Associate Judges, now presiding of the District of Columbia Court of Appeals. Draw near and give your attention. God sent the United States and His Honorable Court. This Honorable Court is now in session. Please be seated and come to order.
Good afternoon, everyone, and welcome to the students here in the audience. We have one case on this afternoon's calendar. We granted oral argument in the case of 24 AA 590 Juan Miguel Valdez versus DC Department of Employment Services.
Good afternoon, Your Honors. May it please the court. My name is Vikram Swarup from Legal Aid on behalf of Petitioner Juan Miguel Valdez. I'd like to reserve 3 minutes for rebuttal.
Sure.
This case asks whether a minimum wage worker who missed a single hearing because he was in the hospital with his mother who was experiencing a medical emergency should permanently lose his right to challenge overpayment determinations that were based on a single piece of evidence that OAH had recently found flawed. Under the governing regulation, Mr. Valdez was entitled to a merits determination if he satisfied 3 elements. First, he missed the hearing. Second, he had a good reason to miss the hearing. And third, he had an adequate defense. There's no dispute that he missed the hearing, so this case is really about the other 2 elements. On the second, the ALJ credited Mr. Valdez's testimony, finding that he was at the hospital with his mother at the time of the hearing. Yet the ALJ denied relief based on a speculative and unclear inference that he had a different reason to miss the hearing, driven largely by the delay between when he missed the hearing and when he filed his motion for relief that totaled approximately 17 days.
Can I ask you, if we agreed with you that there was a problem in the evidence supporting the judge's view of the real reason, where does that leave us? Like how, I mean, I guess you make this argument about the objective way of looking at reason, but it seems like, can you just default back to the reason that's been given, even though we have, you know, it's credited as it happened, but it's not, it's discredited, I think, as to being the real reason. So even if we don't, you know, accept the judge's view of the real reason, how do we get to what is the reason in the record then?
Yes, Your Honor. So there's only substantial evidence for one reason why Mr. Valdez missed this hearing, and it's because he was in the hospital with his mother. There's not substantial evidence for any other reason for him to miss the hearing, and there was no real incentive for him to miss this hearing. He had already prevailed on substantially the same case before the same ALJ a few weeks prior. And at the same time, he was entitled to receive some unemployment benefits at the end of 2023, about $7,000 worth of unemployment benefits that was being withheld from him. So he had no reason to delay the hearing. He had no reason to miss the hearing.
So are you saying that the substantial evidence standard just occupies the whole field here? And to the extent we think the judge made a credibility finding, kind of saying, I don't believe you. I don't know if those are her actual words, but I think it boils down to that. I don't believe that's why you didn't come. I guess, you know, that there's not substantial evidence. I feel like there are separate questions about whether there's substantial evidence supporting things she thinks was his reason and whether there's substantial evidence supporting just her disbelief. It's hard for us to say why she didn't believe him, you know?
Yes, Your Honor. So there's the credibility determination to the extent that there's one made, and I don't think it's very clear in the order that there was a real credibility determination, is really based on why didn't he file sooner? She did not believe his reason for why it took him so long to file, but that's utterly unrelated to the regulatory inquiry at here, which is, did he have a good reason to miss the hearing? Everything that happened after the missed hearing does not shed any light on why it is that he missed the hearing. And here, in this case, there are basically 3 hearings, right? Like there's the one about the 2021 overpayments, there's this one that he misses, and then there's the motion for relief hearing. He attends 2 out of the 3 hearings. The only one he misses is the one that's on the day that his mother experiences a medical emergency. So it's very hard to see how there's any basis to conclude that there was any other reason for him to miss the hearing other than the hospitalization of his mother, which the ALJ again did credit in the course of this proceeding here. And so the focus should not have been on when he found out or why it took him so long to file a motion. It should have been on why did he miss the hearing? Because what happened after the hearing, the promptness of his actions is not one of the factors that the regulation considers. And the regulation that was in place before this one and the one that was in place after this one both do incorporate promptness into them, but this one simply does not. And so focusing on that time period was erroneous and ultimately was the only sort of factor that the judge really looked at other than the fact that his mother was in the hospital.
But then if we think that the court erroneously relied on some promptness factor and attributed incorrectly some delay or used this assessment of perceived delay to discredit the reason that the credited reason that his mother was in the hospital, then what do? Do we just send it back to say now do this again without considering the promptness?
I think the court has a couple of options, but I think the clearest path forward is on the basis of the record before the court. There's really substantial evidence cannot support any reason that he missed this hearing other than the mother's hospitalization. So I think at this point, the court should remand for a merits determination on the ultimate question. That said, if the court I think it is within the court's discretion to remand for additional explanation or factual finding if the court determines that the ALJ's order is simply unclear or that there's sort of one small legal error and that this determination could be made even without that legal error. I think based on the record that's before the court, there's really no reason why there should be a remand for further proceedings on that question because the record is clear as day that the only reason he could have missed the hearing is because of his mother's hospitalization, and that he had no incentive, motive, or evidence supporting any other rationale here.
You mentioned that the court should not have looked at what happened after the hearing in order to kind of ascertain the quote, the real reason or actual reason for his missing the hearing. Is that what you said, or that she should not have looked at this particular, at the delay, as indicative of the reason?
The latter, Your Honor.
Okay.
I think the duration of time that elapsed between the missed hearing and the motion just tells us absolutely nothing
Right.
about why he missed the hearing in the first place. And so,
Right. But there could be some post-hearing evidence that could shed light. For example, if somebody heard him say, boy, you tell me whether, what if the evidence were this? 2 weeks after the missed hearing, he says, this sounds a little heartless, but I'm really glad my mother had to go to the hospital that day because I really did not want to go to that hearing. I wasn't prepared for it.
yes, Your Honor, I think that would be a different case. And I do think that
But that would be evidence that could be taken into account.
I think that's fair evidence to take into account because it goes to the reason for missing the hearing, which is the question under the regulation.
But there's a difference between in that case, he was at the hospital with his mother who did have a medical emergency. And it's assumed he was his mother's ride. Does the fact that he was, in addition to that, kind of relieved, perhaps even happy, that he missed the hearing, is that a relevant consideration? Is that something that the ALJ can try to get at?
I think the ALJ could consider that, Your Honor. I think the
Could.
question is, once we've established that his mother is in the hospital and he's with his mother at the time of the hearing, then the question becomes, if his mother were not in the hospital and he were not there, if he were not with her at the time of the hearing, would he have attended the hearing and
Right.
participated anyway? And so here, there's no substantial evidence to conclude that he would not have been at the hearing and that he would not have participated, but for his mother being in the hospital and him being there with her at the time and the medical emergency that caused that.
Well,
So
or the other way around. had, well, you were just saying, had his mother not gone to the hospital, would he have gone to the hearing? Or had he been prepared to go to the hearing, would he not have gone with his mother to the hospital?
Your Honor, I think here there's only substantial evidence to conclude that he missed the hearing because his mother was in the hospital. If his mother were not in the hospital, it is clear from the record that he would have attended the hearing and that he would have been prepared because there was simply nothing for him to prepare. He had already been to a hearing on this issue several weeks before, and he didn't submit any exhibits. He didn't do anything. He just showed up, put the government to their proof, and he won. And so that's all he thought he needed to do at the time of this hearing. And that's exactly what he would have done and should have done had he had the opportunity to do so. But for this sort of interceding event of his mother experiencing a medical emergency on the morning of the hearing and him having to rush to attend to that on that day. So the court also ruled on that he did not have an adequate claim or defense on the merits. The court's analysis on that question, I believe, is about 2 sentences long. And I think here it is very, very clear that Mr. Valdez does have an adequate defense on the merits. DOES bears the burden of proving the overpayment. Mr. Valdez does not have the burden of disproving it.
You get into that. Is that the right question, or does he have to have an adequate defense on the lateness of the appeal?
Your Honor, I think the fairly read, the ALJ's order does not actually make clear that she's ruling on the adequate claim or defense prong on the basis of timeliness. So I don't think the ALJ's order is sufficiently clear on that. But even if that were the basis, I think Mr. Valdez has a really strong argument on that as well. Again, the standard here is pretty low, right? Like we're just trying to determine whether this is a futile gesture or empty exercise to look at this. Is this sort of ill-fated from the jump? And here, Mr. Valdez explains both in his motion to reopen as well as in the evidence in his testimony before the ALJ that he intended to attach all 3 of the overpayment determinations. And again, he's pro se at the time, right? So he intended to attach all 3 of these documents to his initial filing with OAH, and instead he attached 1 document 3 times, an incredibly human error. And so I think that this is classic inadvertence, carelessness mistake, which goes to the heart of excusable neglect doctrine. And again, he wasn't required and isn't required to prove his whole excusable neglect case at this stage. He just has to show that he has a case of excusable neglect that is worth hearing. And I think it's very hard to argue on this record that he doesn't at a minimum have that showing. And then to the ultimate merits, which is what I think
Isn't there a timing problem though with he knew he had this figured out in time to file a timely appeal?
I don't think so, Your Honor. So I think what happened is that he initially attaches, the 1 document 3 times. And then what he testifies to is a couple of days before the February 20th hearing, he realizes in the exhibit packet that, oh no, I only attached, the 1 document 3 times instead of the 3 documents. But what he also testifies is at that time, he still expected that the court and that the ALJ and DOES would sort of work it out and try to help him out because he's, at the time he's pro se, he thinks this is a problem solving process. So at JA 31, he talks extensively about how at that time, still in the February time period, he thought that it would all kind of work out. And then it wasn't until March 1st when he gets the ALJ's order on the 2021 overpayment that he realizes that those 2 other overpayment notices were not determined. And it wasn't even then that he fully realized. It's a couple of days later when he calls DOES when he's like, okay, where are my benefits from 2023? And they're like, no, we can't give it to you because there's still some issues with your file, that he realizes, oh no, they didn't actually tackle this issue. And again, there's extensive testimony about this in and around JA 31. And so then on March 13th, sort of 12 days later from after the order, and maybe about 10 days after he has this back and forth with DOES, is when he files the motion to reopen, explaining, I'm not good at technology, I apologize, I attached the wrong documents, please give me a chance to be heard on this.
Can I just add again, I'm concerned with sort of the procedure. If we think, as I think you said a moment ago, that the ALJ didn't really address the adequate defense as to the ground on which it denied him relief on April 2nd, right? On April 2nd, the court says, I'm dismissing your challenge to these two notices of determination of overpayment because your challenges weren't timely filed, right? So if we think that the ALJ didn't address that squarely, do we remand for that? And also, do we think that the ALJ had to consider both whether he had an adequate defense to its timeliness ruling, and also, well, I get a little turned around how he would have an adequate defense to the case that Doe's had to bring against him, but maybe you could speak to me about that if we get to the next step beyond the timeliness of the appeal.
Yes, Your Honor. So I think the ALJ's inquiry should have addressed, does he have an adequate claim of timeliness, as well as does he have an adequate defense on the merits? Again, under this low standard of, is there something here worth looking at, right? Like, would it be futile to do that? What the ALJ's order actually does is I think it only addresses the second prong. And so I think the court, that's what's before the court here, is the underlying merits here. So I don't think the ALJ squarely addresses the timeliness prong. But I think if this court were to conclude that it wanted to give the ALJ an opportunity to address that prong, it could. I just don't think that there's any real purpose in that, because it's very clear from this record that he has a claim of excusable neglect that's worth hearing. So I think we can jump to the ultimate merits here, and at the merits.
And I'm sorry, just so I understand, do you think that in only addressing the merits, is it your view that she was saying, I'm, like waiving a judicial waiver or whatever? I'm not worried about the timing, like, or was it just an oversight?
I don't know, Your Honor. I
Okay.
think probably something more like an oversight. And ultimately, I think she thought that the merits were dispositive because Mr. Valdez, as she said, didn't provide any exhibits, right? Like, which is the basis for her adequate claim or defense ruling. And again, Mr. Valdez was never required to provide any exhibits because he didn't bear the burden of proof on the underlying merits, so to speak. And so I think it's reasonably clear that he does have a claim on the merits because he already won this case. There's only one piece of evidence at issue here that DOES has provided. That document has already been found to be unreliable to prove the amount of the overpayment. And then there's also a facial indication on there for the 2017 time period that it needs to be verified. When asked whether it was in fact verified, the DOES representative indicated that it had not been. So I think all of this together is more than an adequate defense on the merits. I see that I'm out of time.
Okay.
Thank you, Your
We'll
Honor.
still give you some time for rebuttal. Thank
I
you.
appreciate that. Thank you.
Good afternoon, and may it please the court, Graham Phillips on behalf of the Department of Employment Services. The court should affirm the ALJ's order for either of two independent reasons. First, she permissibly concluded that Mr. Valdez had not carried his burden of proving that he missed the April 2nd hearing for a good reason. And second, and in any event, his appeal of these two determinations was inexcusably untimely. So I'll start with the good reason issue. And Judge Beckwith, I think I'd like to address part of what you brought up, which is how to think about what the question is here on appeal. Because this is, I think it's undisputed that Mr. Valdez bore the burden of proof on showing that he had a good reason for missing the hearing. And what the ALJ ruled was that he had not carried that burden of proof. The question on appeal then is not a sort of standard substantial evidence inquiry. Instead, the question is, was the evidence in Mr. Valdez's favor so compelling that no reasonable fact finder could fail to be persuaded by it? So it's not a question of, was there substantial evidence for her definitive determination of fact? It's whether the evidence was so one-sided that she was compelled to believe.
But what's the evidence on the other side? There has to be some evidence to support with it. If she's going to reject the evidence he presents or the reason he gives, she has to be able to point to something else, right?
That's right. I think she has to have some reason to doubt. I think that's right.
Right.
And she gave a reason, which I think is quite a logical one, which is the extent of time before he contacted OAH in any way.
The 17 days?
Yes, Your Honor. And I think that
Which she said that normally she would not consider to be a lengthy period of time, but for some reason she then turns around and says, but it's longer than I would expect if, and I can't even remember what she then said. And what is that based on?
So I think that's a distinction between in some sorts of tests like this, there is a sort of independent prompt action requirement. And we acknowledge that there are cases that have said something like 17 or 21 days can sort of be prompt enough to count as prompt action under that sort of test. But I think what the ALJ was looking at that period of time for was something different. I think she was asking if he was prepared and intended to go, had remembered and intended to go to this hearing on April 2nd, and then suddenly at the last minute, this unexpected thing arose, is that the amount of time I would have expected a person to wait before contacting and saying, hey, this emergency arose?
I guess I don't understand the logical connection. I mean, between a 17-day delay or 7-day delay or 21-day delay and a determination of, oh, well, he must have been unprepared. I don't get it. And she doesn't explain, as Judge Ruiz says, alluded to, all she says is, 17 days is not generally an excessive amount of time, but it's certainly longer than I would expect claimant to wait if it is true that he was aware of and prepared to participate in the hearing. She doesn't know claimant. I mean, I don't understand. I don't understand why she's saying this is my expectation as to how soon he would do it if he were actually prepared. I just don't understand the connection.
I'll try it in two ways, Your Honor. So one, I think it's just intuitive that if you are planning to attend, a court date is a big deal. And so if in fact on the morning of your court date, you have remembered and you plan to attend that, but then an unforeseen circumstance prevents you, I think it is human nature to want to contact the court quite quickly to say, I wasn't blowing this off. I had a reason.
I mean, 2+ weeks. I mean, your mom's in the hospital. You're a layperson. You're not a lawyer. You really want this money. Your money is being held up because of this dispute about whether or not you got overpayment. So to get back to them and be like, well, I missed the hearing. Now I'd really like to get back before the ALJ, explain why I'm entitled to these, or I'm entitled to the funds that I'm owed. I didn't get an overpayment. I mean, just none of this seems manifestly, patently, it doesn't suggest failure to prepare.
Well, I guess
particularly in light of, sorry to interrupt you, in light of legal aid's argument that, well, he rolled into the last hearing without really preparing before too. So all he thinks is that he just has to show up and they have to prove their case, and they can't prove their case.
One thing I want to say, Your Honor, I don't think the ALJ made a factual finding that he was sort of decided not to go for lack of preparation, as in the sense of like he hadn't done his homework. She uses the word prepared, but I think in that sentence, what it means is that is equivalent to intended to go. So I think the other possibility that would be on the ALJ's mind is just that he could have forgotten, he could have lost track of this thing, and I think that's not irrational for a fact finder.
But that's not what she says. She says because he wasn't prepared. You say we should read into prepared that he forgot?
I think that if it was true that he was aware of and prepared to participate, essentially means if he remembered and intended to go.
Well, and maybe he forgot because he was doing something else. Namely, he was taking his mother to the hospital, or he was accompanying her to the hospital. And in terms of whether it would be usual or normal, or you would expect, or she would expect that somebody having missed the meeting, the hearing, would say, oh, I better get back to them right away. Wouldn't you need to do a little bit more fact finding inquiry? I mean, do we know what happened to the mom? What else was going on during that 17-day period to see whether in fact that would have been in the normal course of right thing, the expected thing to do?
I don't think we do have more details, but again, I think it was Mr. Valdez's burden and he had the opportunity to testify as thoroughly as he wanted to about
No, I'm
that.
just going to what the ALJ said, what I would expect. That seems to me to be a totally fact-free supposition, and she has to base it on something, right?
So I think it is not, and I understand different fact finders could draw different inferences from these circumstances. And we're not making an argument that under these circumstances, an ALJ would be compelled to find the way that this ALJ found. But I don't think it's an irrational line of thought. And another aspect of it is
But I'm sorry, but let's keep on with that. Inferences, whatever. Is it a necessary inference from what the judge said here? He didn't show up because he wasn't prepared. Question what prepared means. Because you questioned that. I thought I meant he wasn't ready in the sense of homework. Or not ready to face it for whatever reason, although that's odd because as Mr. Schwab says, after all, he had prevailed before. Why shouldn't he be brimming with confidence that he's going to go in and win again? So the inference, the logical inference to me is that had he been, quote, prepared, he would not have gone to the hospital with his mom for that medical emergency. And is there any, because that is a logical inference, right? Is there any evidence whatsoever to support that?
no, but I guess I don't think the ALJ made a factual finding of her own about what the real reason was. And I don't think she was,
Oh, she didn't.
I don't think she was required to.
I thought she did.
No, I think, her opinion is phrased over and over again in terms of Mr. Valdez did not prove, I was not persuaded. Claimant has not proved through credible evidence. It's all framed in terms of failing to carry his burden of proof. I'm not persuaded. And I don't think the ALJ.
But the question, okay. She's not persuaded by evidence that she does credit that he was at the hospital. That's evidence she credits, right?
Yes.
In fact, that's undisputed. So what is there for her to say he didn't bear his burden of proof?
Well, one is the point we discussed, that I think she could just sort of doubt that based on the timing of his coming back to court. And one point I just want to make sure I get in there, as I do think it's notable, again, if he was prepared and ready to go, intended to go, and then an unforeseen circumstance came up, it is very strange that he did not, at a minimum, seek relief within 10 days. The order itself tells you sort of the importance.
He gave a reason, right? He thought it was all over until his wife kind of explained to him that in fact there was something he could do.
I don't understand that reason because, again, the order itself tells you the opposite. The order tells you that you can ask the ALJ to change the order, and that there's a significance to doing that within 10 days. And again, the hypothesis here is that on April 2nd or the day after, he knows he's missed this hearing, and that this is important precisely because it involves.
When does he actually get that order?
So he gets that order on the 2nd itself, on that day. Now, it is not clear that he read it.
And he gets it how? I'm sorry, he gets an email?
By email and
Yeah.
and by mail. And one thing I do want to urge the court to do is I think it's important to go through and read Mr. Valdez's testimony on this and read it, with a skeptical eye, because I think the question again was this fact finder compelled to believe this account? And there are quite a number of just obvious on their face inconsistencies and inaccuracies in his testimony about this series of events. And so I think that can help explain the ALJ's reaction here. I mean, for instance, most notably, the question of when did he realize he had missed this hearing, I think is quite an important one. And he shifts his story several times throughout the course of just a few pages of testimony. First, he testifies that he realized on April 2nd itself. He says that twice. 1 page later, he says that he didn't realize until the 18th or 19th.
Why does that suggest that the reason he gave was not his reason. Because I read the transcript and I saw, I understand the inconsistencies you're pointing to. It sort of seemed like didn't come across to me as that odd or, unusual. And I don't know if there was a language problem, but there definitely was some, I don't think he was saying, I actually filed this thing on April 2nd. Everyone knows he filed it on the 18th or the 19th, and that's one of the inconsistencies. I don't think he might, I feel like there are just dates and memory issues.
Well, Your Honor, he did testify. The first version he testifies is later on that day is when I remembered, which was when we filed the motion to reconsider.
Yeah, but I just think he doesn't mean that, right? He's not lying.
I think that is one view a fact finder could take,
Hmm.
but I think another view a fact finder could
That's
take.
not the view that the ALJ, I mean, the ALJ didn't hone in on this, right? As far as sort of the reason he didn't show up, right? The ALJ just gave this now kind of thoroughly confusing statement about, well, I would think that if he were, aware of and prepared, he would have, sought relief before 17 days had elapsed. I mean, if we are not, if we don't think that that is a good reason not to discredit his testimony, right? That you can infer from delay that he stayed away from the hearing, not because his mother was in the hospital, but because he did not want to attend the hearing. Then what do we do? Do you think that we can we can sort of say, well, it's okay because the ALJ saw him and clearly just didn't credit him for saying that he was absent from the hearing because his mother was in the hospital?
So I do think the ALJ's bottom line is that he has not proved through credible evidence that he had a good reason. And so I do think is at bottom, and the evidence of the reason was his say so. So I think finding him not credible.
But your parent being in the hospital is at least theoretically a good reason, right?
It is theoretically, and
I'm just trying to sort of, if the ALJ doesn't cite something else, if we put aside the 17-day delay and think that's doesn't really have any logical impact as to why he did or didn't show up to the hearing, then I guess this is back to Judge Beckfuth's initial question, sort of, are we stuck with the theoretically good reason because the ALJ just didn't supply, right? I mean, this is not the case where, this is an outlandish hypothetical, but, say Mr. Valdez has a twin and the mother gets ill and there's evidence that Mr. Valdez turns to his twin and says, I'll take her to the hospital. I don't want to go to my hearing. You go, do something else, even though you're available to take her to the hospital. That would be some evidence then, if that came before the ALJ to say, well, yeah, she was in the hospital, but there was somebody else, his twin brother, who could have taken her to the hospital and you could have gone to your hearing. That's not what you did. But we don't have anything approaching that sort of evidence in this case. All we have is, yeah, she was definitely in the hospital. We definitely credit that. And there's kind of nothing else. Again, if you put aside, and I know you would like us to look at the delay, but if we're not going to look at the delay,
that's
all we
think,
have.
yeah, I think I have two fallback or two points. I do think that the right answer is that because this is ultimately based on a finding his testimony not credible, I think that is reason to affirm. And I don't think there is an obligation for ALJs to sort of explain in detail why they find witnesses credible or not credible.
Sorry, can you I just can't remember where the ALJ says I don't credit him.
Sure, she says it two places, both on JA4, the sort of last full paragraph, and then the paragraph that carries over to JA5. I conclude that claimant has not proved through credible evidence that he had a good reason for his failure to attend the hearing. And later down at the very bottom of the page, in the middle of that next paragraph, I do not credit claimant's explanation for his failure to appear. So I think then you have to ask, was it permissible for the ALJ to find him not to be credible? And I think the answer is yeah.
Can I just press, is that definitely what she's doing? Because you were saying, doesn't that all boil down to her thinking that he didn't behave the way she would expect? Which I feel like you were presenting as not a fact, not a credibility determination, just a logic conclusion on her part.
I think it goes to, do think that goes to credibility. What I'm resisting is that she made a finding of fact about the real reason. And that's what I think an ALJ doesn't have to do in this sort of circumstance. My fallback, if you're not persuaded by that, is just the question of sort of, can you outright reverse? And I think if you find the 17-day delay sort of irrational, I think you need to find it sort of an irrational thing to base this on. But if you say that's not good enough, then I think you need to remand, because with further explanation, I think the ALJ could say, I listened to his testimony, I found it full of inconsistencies, and it left me with the impression that he was not keeping a close watch on these cases based on the way in which he failed to appeal these determinations, and he had a poor memory for what orders he had received when, and that is why I just, on balance, find it, sort of, maybe it was because of the situation with the mother, but maybe he just wasn't keeping track of this stuff and would have missed it anyways. And I think that is ultimately turns on credibility. And
you said that we would have to find that the inference of the real reason for not showing up from the fact of this 17-day delay, we would have to say that that was irrational. First, I'm close to there. Just a heads up. But is that the real? Is that what we're supposed to? Is that the standard? Doesn't it have to reasonably flow from the facts of the case? And what are the facts of this case, other than the actual 17-day delay, that makes that a reasonably flowing inference or conclusion?
Well, so one thing might be, I concede that the way I'm using irrational might be equivalent to unreasonable.
Okay, great. Good.
I don't think
Unreasonable in this contextual, factual.
in this context, but I don't think it needs to be. I don't think it needs to be based on some particular facts of this case. I think fact finders
But it can't fight. It shouldn't fight the facts in the case. At a minute.
I don't think it can be contradicted by facts that the ALJ finds.
So I'm trying to understand what is the confluence of facts that you think gives a basis, gives some support to that conclusion.
I think
in this case.
So I think it is a general principle. So I'm not saying it's based on something specific about this case, but I don't.
But doesn't it have to?
No, I don't think so. I think fact finders all the time make inferences based on common sense and experience that's not grounded in like specific testimony about that's given in the particular.
But where you do have facts in the case, do you just go on a flight of fancy?
No, and again, I think maybe we're just disagreeing about whether this inference she drew is contradicted by the fact of his mother being in the hospital. I mean, if you think that's flatly contradicted, then.
Well, I'm just trying to see before I can see whether it's contradicted, I would have to know what facts, real or from common experience, would support.
Sure, and can I try on the common experience point?
Yeah.
I think if you look at the case law that the parties have cited in this case, there are, by my count, there are 4 cases that involve this kind of instance where the party seeking post-judgment relief had intended to go to the hearing, and then a last-minute thing came up and prevented them. Frausto, King versus DC Water, the Prime case that we cited, and the Hasbrook case. And I think it's just interesting as a descriptive matter that in all 4 of those cases with pro se plaintiffs, the person who had the last-minute emergency did contact, at least informally, did contact the OAH in some of them and the Superior Court or DC Water. I just think that goes to show that this is not an unreasonable inference to draw from sort of our experience of how people deal with missing important things like court dates. I see I'm already out of time. I would like to shift briefly into the question of the untimeliness of the appeals. And I'd like to go through the facts here because I see them very differently from my friend on the other side. So the story is indeed what Mr. Valdez testifies at the hearing is that the initial problem was that he accidentally submitted duplicates of the one determination. And that, that is maybe an understandable mistake as far as it goes. But then I think we need to sort of look at what happened next. He says one important date here, I think, is actually February 6th, because he says the problem was I did these duplicates, and he says, and I'm reading at JA 29, and I know that for the first meeting, one of the duplicates was thrown out because it was deemed a duplicate. That was the dismissal of a sort of other OAH case, which is discussed by the JA here at JA 4. At the top of JA 4, she notes that this DOES-140 was dismissed as duplicative on February 6th. So I would argue that on February 6th, he is on inquiry notice that what he has done is filed duplicates, not 3 separate determinations. And he says he set out to submit the 3 separate determinations. So I think he understood these are distinct determinations covering different benefit years for different amount of money. And to challenge them, I need to submit each of them that I'm trying to challenge, just as they say themselves. Then the next big date is February 20th. That is the date of the hearing of the first case. And Mr. Valdez testifies that by that time, I realized the mistake I made. So he knew, and how could he not? Because at the hearing itself, all of the evidence is about just the one determination.
Can I just ask a factual question? I'm sorry to interrupt your flow, but this is one thing I don't understand is when he filed those duplicate determinations, was there like some kind of a pleading or filing with that made any, that addressed, cited to all 3 of the determinations or is there anything that flagged that this was about 3 of them?
Not that I am aware of.
Okay.
It seems based, I think, on the record here and from what I know of the record in the first case, that Mr. Valdez just submitted the determinations themselves. I don't think he put a cover sheet.
So that's the act of appealing is,
I mean, I think OAH does want you to put a cover sheet and explain, and they have these. But I think, as this case showed, even if you just submit the determination itself, I think they understand what you're trying to do, and they say, okay, you're filing an appeal of this. So on February 20th, he knows, he has realized the mistake I made, that he has not appealed these other determinations.
I'm sorry, I'm going to interrupt your flow too. I mean, February 20th, that's already too late, right? He has to appeal by February 6th.
That's right. That is already too late. But I don't think the fact
So
that,
I guess I'm curious why we're talking about what he knows as of the 20th.
well, because I think,
Because at that point, I mean, he's late,
right. I'm trying to be charitable and say that even if you say the clock only starts to run then, which again, I don't actually think is appropriate because I think he's on inquiry notice before then. But even if you start the clock then, he misses the deadline by a significant amount. And there's really no excuse that I can understand for not appealing after you have already realized the mistake. And then come March 1st, you get the order in the first case, which, as the exhibits and evidence that was presented on February 20th would have already made clear to you, it is only about the one determination. And the decision itself is very clear. It only talks about the one determination. It ends with a sort of, the decretal language is like he does not owe this specific dollar amount. That is the specific dollar amount in just the one determination. So even at that point, again, I think that's already too late. But even if he needed that to be sort of fully certain that he has not appealed these other 2 determinations, there's no excuse for then waiting another 12 days, again, when you're already way past the deadline, to appeal these other two determinations. And so, you know, our view is that
He does give some explanation along the way. I understand your point that it would be increasingly weak as those dates go on, but he talks about, what is his, now I'm forgetting what it is. He has, oh yeah, that he thinks the government, you know, knows they have it all together and they'll make it, you know, he just seems to have a sense that, well, they sent these to me, so it'll get worked out. Even if I applied, you know, I didn't attach the right ones, I'm sure they have it in their files, or, you know, which is how I understood his comments on that.
I mean, I don't think that from the start, I don't think that's reasonable. I mean, that's not how the determinations themselves describe it. I don't know why you would assume that. But even if you assume that going into the February 20th hearing, I think this hearing, you know, despite what the exhibits show, I think it's going to cover everything. Well, by the end of February 20th, you know, it did not cover everything. And you know that the department did not sort of sua sponte bring in your other determinations for adjudication. So I don't understand how that
So, okay,
mistake.
so what does that do? So that means he was even a little bit later in, I mean, I'm trying to understand what this is relevant to.
So my point is that even if very charitably you say that the 15-day clock began to run on February 20th,
Right.
he was still untimely. Even giving him that much leeway, he was still untimely.
Well, we know he was untimely. The question that we go back to okay, he was untimely. The question is, should he be allowed to, now we go back to, you know, the reason for not attending the hearing or his subsequent request. Is this what we're talking about now?
We're talking about the timeliness of his appeal of the determination. So
Right.
essentially, these determinations were mailed on January 22nd.
Right.
And he did not appeal the two that are at issue here until
understand.
March 13th. And my point is that, you know, even if you spot him everything until February 20th, there is no excusable neglect for that further delay.
So now we're under an excusable neglect standard and you're saying because he had all this time, he should have filed before.
Essentially,
Like what he did.
that there has been no good reason given for why he did not file at a minimum within 15 days of February 20th. I can't understand how he could at that point have thought he had already appealed these or that the earlier adjudication encompassed them. You know, the sense you get is that he realized the mistake and just sort of hoped it would all work out somehow, but that's not excusable neglect. Excusable neglect doesn't, you know, cover just even run-of-the-mill errors. And I think this is something worse. This is sitting on your hands and not bringing up what you have realized is a problem.
Sorry, isn't it good cause or excusable neglect?
That-
And I guess if we're looking at, maybe I'm looking at this too narrowly, if we're looking at the time period between January 22nd, which is when he gets the 3 notices, and February 6th, when the time to appeal expires. In that interim, he has appealed one of the 3 notices successfully. And it's obvious that he is submitting one of the notices multiple times, which is unnecessary. And so isn't that the window of time that I'm just confused as to why we're looking at anything beyond February 6th. And shouldn't we be looking to say, well, the reason that he didn't file by February 6th is because he screwed up in a technological sense?
Well, Your Honor, I think if everyone agreed that that there was some totally legitimate, indisputably legitimate basis for confusion that did not go away until February 6th. But then he just decided, I'm just going to wait another year because I don't want to deal with this right now. I think obviously the fact that he had a good excuse for the first little window would not absolve him of the fact that then he takes a year for no good reason until he finally appeals the determination. Now, that's obviously far more extreme than the facts we're dealing with here, but I'm just trying to make the point that I don't think it makes any sense to say, well, he had a good reason maybe from January 22nd until the original deadline. I think you then still need to ask, okay, well, you didn't appeal it on the 6th or the 7th. You waited until March 13th. What is your good reason for that delay? And I don't think there is any. You're right that the statutory language is good cause or excusable neglect. I think the right way to think about here, this is an excusable neglect case. And I think the way to think about the distinction between those is sort of, if you look to Rule 4, Appellate Rule 4, I think that's sort of the most analogous type of deadline. And the commentary to the federal Rule 4, which predates when this statute was enacted, says that the distinction is basically excusable neglect is for situations where there is some kind of fault, but it might be an excusable fault, and the good cause standard applies in situations where there is no fault, excusable or otherwise.
Referring to Rule 4, and I understand that that uses the same term, but here we are in an administrative proceeding with an unrepresented litigant. We have in our court, and I would assume, I don't know, you tell me, whether in the agency context there is also this preference for resolution on the merits rather than procedural default. I mean, if we take a step back and look at, the kind of situation we're dealing with here, which is actually quite, it's not unusual, right? To have an unrepresented person who is clearly at one point confused and thought he had done the right thing, but didn't. And you're right, maybe he could have moved a little bit faster, but there's no indication that this is someone who's just blowing off the whole thing, right? And it just seems to me that the hammer is coming down pretty hard in this case, where there should be more leniency or giving the joints.
So I disagree, obviously, Your Honor. I mean, I think I do understand that impulse, and I'm not denying the premise of in
It's
general.
more than an impulse. I think it's rooted in this notion that we try to get to the merits and reach a just resolution in cases as opposed to have people default their rights.
I think we do, as long as people are exercising adequate diligence of their
Yes,
own.
well, okay.
So I don't think that is here, because again, I think by February 6th, you've got inquiry notice that you haven't actually appealed these other determinations. By February 20th, it is clear you have not appealed them. And to then, his testimony at several points is, well, I just assumed. Again, I think this was hoping that somehow it would work out. But what I think he could have done, and would have been the right move to show diligence and sort of affirmative good faith, is on the 20th, you realized, wait a second, I meant to appeal these 3 different determinations. The other aren't in the exhibit packet, and this hearing is not covering them. I was trying to cover all 3 of these things. I think if he had just said to the ALJ, even in some informal manner, my intent all along was to appeal all 3 of them. And if I have not done that, tell me what I need to do to effectuate that. Mm-hmm. And it's not hard. I mean, again, filing an appeal of these sorts of determinations with OAH is not a complicated process. OAH they let you do it in person, they let you do it by mail, they let you just email it in. They also have a filing system that you can use. And as this case exemplifies, all you need to do is give them the determination and say, you don't even have to give them a cover sheet. You just have to indicate, here's the thing, I'm trying to challenge it. And I think that.
Sorry, we don't have the February 20th transcript, do we? So do we know what he did or didn't say?
You don't have the transcript, but what you do have, again, it was the same ALJ.
We have the ALJ's order.
Yes, and if I can just point you to, again, JA4, she talks about the February 20th hearing. He participated in that hearing. I only heard evidence and testimony about one of the 3 determinations, and I issued a final order addressing only that one determination. And I don't take Mr. Valdez to ever dispute have disputed that. That in fact, he said something during the earlier hearing to bring up these other two.
And the evidence at that hearing was presented by DOES, right?
That's right. And it was limited to the 2021 determination in the period of time that covered. And it didn't address the other ones. And, there's nothing in the records to suggest that he ever was confused about that or said something at that hearing. Again, his testimony seems to be, well, I just sort of assumed it was too late and there was nothing I could do. But again, I just don't think that's diligence. And I think diligence is a key part of it.
Do we know how much discussion there was during the hearing, that he would have actually been aware of what was being presented?
Well, one thing we know from his testimony is that he did get the exhibits ahead of time. And again, I keep quoting this phrase because I do think it's important. I realized my mistake. So he knows by that point that the exhibits don't cover these other determinations. And then I don't think we have any basis to doubt the ALJ's summary of her own hearing that it did not cover them. And so then I think we're left with no understandable reason why the appeal of the other two determinations was not filed promptly. And again, sort of looking to other cases that have been brought up here just as illustrative of what can happen, the Savage Bay and the Edmasu cases are the two cases that are most directly about this sort of issue, excusable neglect for failing to timely appeal a DOES determination. And it is the case in both of those. I think the parties had much stronger reasons for sort of missing the original deadline in the first place. But then I think an important thing is that in both of them, when they actually get notice of the determination, they appeal that day. It's either that day or the very next day. And so again, I think this case would look a lot different if on February 20th or February 21st, and maybe even March 1st, if you want to go that far, he had filed the determinations then. But I do not understand from the record why it is he did not file them until March 13th.
I mean, I guess, if we had the February 20th hearing, and if it were clear at the hearing that the ALJ had told him, look, I'm just, we're here, we're only here on this one notice of determination. And, that's the only, all the evidence is only going in as to this, I don't know what the ALJ said at that hearing to him that might have prompted him to be like, wait, what are you talking about? Only one? I tried to submit 3, or, it just, the record seems murky to me without more information.
I don't think,
I guess I'm agreeing with you that there could be scenarios where we could look at this and be like, yeah, he really should have said something. But if we don't have the transcript, it's hard to say what he should or shouldn't have said, or what he did say. This annotation in the appendix on page 4 just seems to be talking about the evidence, but it doesn't necessarily preclude some sort of ham-fisted attempts to say something that was garbled. Just reading the transcript from the April proceeding, that doesn't seem out of the realm of possibility.
Your Honor, I think if that happened, you would be hearing about it from the petitioner in this appeal. I think that would be, if there were further evidence, and the hearing that occurred on May 16th, it was in part about the timeliness question. That the ALJ sort of trifurcated it, like, first we're going to talk about the motion for relief, then we're going to hear testimony and evidence on the timeliness question, and then I'm also just going to go ahead and do the merits, sort of just in case. So I think this was his opportunity to testify or otherwise indicate. At the February 20th hearing, I argued that the other determinations were part of this case somehow. And I think the fact that he has not is telling. So I think unless,
Not even argued, but your point was he should have spoken up. And I'm just wondering what would have prompted him to speak up.
The fact that he had realized his mistake that
Right, but I just, not knowing how the case was presented and discussed, this is all sort of, it makes sense to you and me with people, we have legal training to know that you have to put an exhibit into evidence for it to actually be considered, right? And, those sort of procedural rules of the road. And if you don't have that training, then you might not understand, well, wait a second, if I didn't put it, they're not talking about it, this is completely off the table.
Well, one thing I'll say is,
And if the ALJ doesn't say anything expressly, we're only here for this.
he does not testify that he was confused about the scope of the hearing, as it was unfolding. And
Was he asked at the April hearing that if he was confused about the February proceeding? I mean, maybe I can't
I don't
remember.
know that he was asked that directly, but again, I think this was his opportunity to put on the case for why, in fact, why his neglect was excusable. And so I think to the extent that he has not put forth the story, that doesn't weigh in his favor. And again, I guess just on a final note, as I'm well over time, even if that were true, again, the final order in the first case could not be clearer. The final order itself, and that is in the record, that it addressed only the one determination. Again, ending with the sort of dollar sign amount that is specific to that one determination. So I do not understand how, at a minimum, after getting that and seeing that is entirely about that one determination and it speaks only to that one liability, you could think that somehow it had covered distinct determinations for distinct times for distinct dollar amounts.
Well, I thought, sorry, and I know you would like to sit down.
You're the judge, Your
But
Honor.
I thought his point was, well, I did realize after I got the final order. No?
Well,
I mean, that's why he files the appeal.
I think actually his testimony is more like that he just assumed that the whole case was already done with. Again, that's totally unreasonable if you actually read the order. And then later he was having these difficulties getting prospective benefits, and that's what caused him to call DOES. But I don't think the fact that you finally run into a practical impediment, and so now you realize I have to do something, is the same thing as a justifiable excuse for not doing something much earlier. And again, it was the final order comes out on March 1st, and he does not file these appeals until March 13th. Unless the court has any further questions, we ask that you affirm.
Thank you. Mr. Swarup, we'll give you 4 minutes on rebuttal.
Thank you, Your Honor. I'd like to start where my friend on the other side concluded, which is with the adequate defense argument. And I think what's really important here is that all of this discussion about timeliness, which was the exclusive focus of both the argument that you heard today and the briefing, is not really in the ALJ's order at all. I just want to read quickly from JA4 what the ALJ's entire analysis of the claim or defense on the merits element is. Claimant also did not state any claim or defense in response to the underlying notices of determination of overpayment. Claimant also did not submit any exhibits for use in the hearing that might suggest he had an adequate claim or defense, even the absence of any testimony or proffer. That is the entirety of the analysis. So I think we're reading a lot about timeliness into those sentences, and I think that is fairly contrary to this court's administrative law case law, which says that that it has to be pretty apparent from the face of the agency's order what the agency is doing for it to be on review properly. The other thing that I would add to that is that this is a low standard. It's just a futile. We're just trying to determine whether it would be futile to look at this question. And so as we dig deeper and deeper into the weeds here, I'm not sure that is really tied to the actual inquiry that is before the court. And then lastly, kind of on the merits of that point of the timeliness piece, it's true that Mr. Valdez indicates that sort of on or around the date of the hearing, the February 20th hearing, he does start to realize that he made a mistake. He understands the fact that he did not attach the 2 additional documents. But what he does not understand, again, as a pro se person who's navigating the system, expecting the government to try to help him out, and he got all 3 notices at the same time, he thought they would be dealt with at the same time. But what he does not understand at that point is the legal provenance of not failing to attach those documents, which does not become clear to him until some days after March 1st, when he calls DOES and says, hey, can I get my benefits? And they say no. That's when he really understands what's going on here. So I think the standard for adequate claim or defense is easily met here by what Mr. Valdez put into the record below. And then on the good reason analysis, all I'll say is, there is again this focus on the 17-day delay, but he was told that he had 120 days to file a motion to reopen. That's what the regulation says, and that's what the notice that he receives along with the April 2nd order says on its face. And it does not include any indication that some promptness was required or anything else was required. So there really is a little bit of a bait and switch going on here between what OAH and the agency told Mr. Valdez and then what they ultimately expected him to do. And I'll also add that there are just no cases that say that a 17-day elapse of time between a missed hearing and a motion to reopen is untimely. If there are no additional questions, I'll conclude by just saying that, this is a case with a pro se litigant there are two barriers between him and getting to the merits of this. The first is that he attached the wrong document. That's happened to all of us. We've all attached the wrong document to something. And the second is that he had a medical emergency for a family member that blew up his day and threw his life into disarray and threw his schedule into disarray. That has also happened to all of us. To expect him to do more than what he has done here, I don't think is required by this court's case law, and this court is very clear that procedural irregularities or technicalities are not meant to stand between a pro se litigant like Mr. Valdez and an ultimate determination on the merits. So we ask that you reverse and remand for a merits determination on the questions of the 2017 and 2019 overpayments. Thank you, Your Honors.
Thank you very much. Thanks to both counsel for your arguments today and your very nice briefing. The case will be submitted and we are adjourned.
All right. This honorable court is now adjourned.